So good evening. My name's Jeff King. I am a co-convener along with Kevin To of the Quain Lectures. Welcome to UCL. It's great to have Professor Jeremy Waldron giving his third Quain lecture. I gave a long introduction to Jeremy Waldron's work on Monday, and my colleague Kevin To. You can hear me properly? My colleague Kevin, who's just interjected here, he spoke just yesterday about Jeremy's collegiality and his intellectual breadth. And so I'll be brief in my introduction tonight. That is for Professor Waldron's third and final Quain lecture this week. Professor Waldron has delivered several prestigious public lectures, including the Storrs Lectures at Yale, the Holm Lectures at Harvard, the Tanner Lectures at Berkeley, Gifford Lectures at Edinburgh, Seeley Lectures at Cambridge, Carlisle Lectures at Oxford, Wesson Lectures at Stanford, the Hamlin Lectures at diverse locations across Britain, and the Daniel Jacobson Lecture in Jerusalem. So after reflecting on this record, Kevin To and I agreed that he was probably now ready to deliver the Quain Lectures in Jurisprudence at UCL. Now, beyond that dazzling list of distinguished lectures in elite institutions, the most important fact is that, to my knowledge of these events, all of them led to notable and often agenda-setting contributions to jurisprudence or political theory. And on this basis, we can expect tonight not only to hear an enjoyable lecture, and an accessible one, as is his way, but to witness the third chapter in an intellectual event. Now, before I hand over to our speaker, I want to remind the audience that while the lectures are complete here tonight, the series finishes tomorrow with our lineup of distinguished commentators, Professors Mitch Berman, David Enoch, and Nina Varsava are each keynote-type speakers that we've improbably managed to have join as commentators. So tomorrow between 1 and 3 p.m., we will hear their critical reflections on the Quain Lectures and Jeremy's rejoinder to them. We hope you can join us for that as well. And without any further ado, I'll hand over the floor to Jeremy. Please join me in welcoming him.
Thank you. Good evening. Thank you, Jeff. It's very good to be back here again. Seems like a home away from home. We had the second lecture yesterday, and when we finished yesterday, we were considering the principle of the rule of law. I was suggesting that despite its popularity, despite its significance in our political philosophy, it didn't really qualify without reservation as a normative legal principle. Instead, I suggested that the rule of law in some of its applications works more like an array of Fritz Schulz's characterizing principles. Indeed, one can easily imagine the rule of law or legality taking its place among the principles cited in Schulz's book alongside authority, liberty, security, and the like. So, before going any further, I would like to review where we've been so far in the first two of these Quain lectures, so that I can identify the threads that I want to take up for this final discussion in lecture number 3. Our questions are these: what are legal principles? Can anything be a legal principle? Can they just be made up as needed? And if so, can they really settle anything? Those are the questions, and here are the points I've tried to highlight. We're exploring the suggestion that besides rules and besides enacted standards, the law of any sophisticated jurisdiction is characterized by principles. The insight is Ronald Dworkin's, although it must also be credited to Henry Hart and Albert Sachs in the legal process materials used at Harvard Law School in the 1950s, which of course was where Dworkin studied law. To illustrate how these principles are supposed to work, I used the well-known case of Briggs and Palmer, where a young man who poisoned his grandfather was denied his inheritance under the grandfather's valid will on the basis of a principle that said, the courts should not help anyone acquire property by his own fraud, or no one shall profit by his own wrongdoing, or something of that sort. So Mr. Palmer lost his inheritance, as well as suffering a penalty for second-degree murder. Although the phrases in Briggs and Palmer roll off the tongue, the thing about a principle is that it has no canonical formulation. And this raises a question about the looseness of its application, particularly in an area where precision is at a premium, as it is so often in legal matters. For example, is the wrongdoing principle cited in Riggs against Palmer just about fraud, or is it about all forms of wrongdoing? Does it have to be about crime, like murder, or could it be civil wrong? Does it have to be a legal wrong of some sort as opposed to moral turpitude in itself? And that in turn raises the question, can anything be a legal principle? Can we just make it up and formulate it as we please? What constrains the choice of principles that we deploy to make a case hard and to resolve it? Do we just make it up to patch over the gap between the agreed facts of a case and the remedy we want for our client? And if we can just make a principle up, we have to assume that our opponents in adversarial legal proceedings can do the same with loosely defined and made up principles of their own. Is that a problem, or is that just the way things are in the legal system? In yesterday's lecture, I introduced the topic of non-normative principles, principles designed to characterize our legal system, not to stipulate its normative outcomes. I found no difficulty in frank acknowledgement of the fact that we do or may just make up these non-normative principles as characterizing bases for thinking about the character of our legal system. We make them up. They are, as it were, hypotheses, interpretive hypotheses about a social science analysis of a practice. And that's the way that they work. So they're really to be distinguished, at least in principle, from the principles that have a more normative character. Characterizing principles have a role in our overall social theory that is not impugned either by their adventitious character, we just make them up, or their formulaic looseness. Everybody knows that social scientists organize their materials in various ways along lines sometimes suggested by Max Weber and others. Even principles that are avowedly normative in character may be less so than they seem. Even the ones that are avowedly normative in character may be less so than they seem, and this is my sixth point. For they may address different audiences or offer only vague guidance to those they do address rather than decisive resolution. They don't give us something we can necessarily count on. So the distinction between normative and non-normative principles that I outlined yesterday is both vague and indeterminate, and none the worse for that. So that's where we got to. And as I said, we ended up talking about the rule of law, which is a complex, hybrid principle that is normative in some respects and non-normative and descriptive in other respects. So, now, today, the rule of law helps us with yet another distinction that I would like to set out this evening. I want to consider principles that present themselves as large-scale political positions, large-scale political positions to be invoked and appealed to when we construct and interpret our constitutional arrangements. These are principles that operate on a much larger scale than, say, the wrongdoing principle in Riggs and Palmer, as the nobody should be permitted to profit by his own wrongdoing. These grand political principles come surrounded by clouds of political theory. The rule of law is one of these. So is the separation of powers, and I'm going to focus particularly on separation of powers as a principle. So is federalism, so is loyal opposition, so is the principle of democratic accountability. I believe that these grand political principles need to be subjected to critical scrutiny, similar to the scrutiny that we applied to ordinary principles like the wrongdoing principle in Riggs against Palmer. But they are also like some of the non-normative principles we considered in Lecture 2. They represent staging posts in political as well as legal argumentation, directing our attention towards aspects of the choices that we face that promote the large-scale and systemic effects whose importance these principles emphasize for us. So let's try and figure out how these grand political principles fit into our analysis. What can we say about their jurisprudential status? What can we say about their status as both legal principles and as principles of political philosophy? As I said, the separation of powers is going to be my paradigm this evening, and I'm going to think about that as a grand political principle that we hear of and we see bandied around in legal and political argument. Now, one possibility is that when people talk about the principle of the separation of powers, they're really using the word principle in a way that's quite different from the way the word principle has been used so far in these lectures. Their use of the word principle may not have much in common with the sort of provisions that Ronald Dworkin identified. Certainly they seem to serve a different function. For grand theoretical positions, they are markers for grand theoretical positions that fill out our constitutional doctrines. But from time to time, they are also presented as a basis for resolving legal problems. I have in mind the recent use of the separation of powers to settle issues in American constitutional jurisprudence. So they're used not just in political theory seminars, but they're used in American courtrooms. And I hope you won't mind that I'm going to focus mainly this evening on grand political principles in American constitutional law. After almost 40 years of living in the United States, I'm most familiar with that. But a lot of what I want to say can apply to the way similar, or at least superficially similar principles are used in the constitutional law of the United Kingdom. Englishmen too speak of the independence of the judiciary and the separation of powers. They treat those as principles. Englishmen too speak of the rule of law. I made a point of focusing on Albert Dicey when I was discussing that yesterday. Even if these principles have to operate in a different sort of environment, compassed around with other norms that are alien to Americans, like the sovereignty of Parliament or conventions regarding the authority of the monarch. Actually, lawyers in the United Kingdom may be more comfortable than their American cousins in talking about emergent principles rather than enacted principles of the Constitution. In America, we are preoccupied with the text of the enacted Constitution. In the United Kingdom, people are used to, and they are familiar with the idea that the provisions of the Constitution emerge from the law rather than having been laid down and codified as such in the text. So I think they will understand, I think British lawyers will understand, I think you will understand what I mean when I talk about these things. Some of these grand principles are too unwieldy to do focused argumentative work on their own. The rule of law, for example, has so many manifestations and comprises such a variety of propositions and provisions, and is controversial in so many different ways that it cannot really be expected to drive a contested argument forward. The deployment of such principles in particular disputes usually involves a tendentious move in theoretical argument that maybe enriches our understanding, but doesn't really settle anything. So one possibility might be just to regard grand political principles as decorative, at least so far as the law is concerned. But sometimes they do play a role in legal analysis, particularly in constitutional law, particularly in American constitutional law with its juridification of politics. Think of the role accorded to the separation of powers in a case you may not have heard of, but it was a very important recent US Supreme Court decision about presidential immunity in the 2024 case of Trump against the United States, which I will say a lot more about in a moment. The question is whether this is an entirely different sort of role than that envisaged for legal principles in Riggs and Palmer, or is it just a difference of scale? Can the grand principles of politics really settle anything? And perhaps the reputation of these principles depends on their chameleon-like capacity to adapt to the needs of any argument. The grand principles I have mentioned, separation of powers prominently among them, certainly do have some of the features that make their more ordinary brethren problematic. There is their emergent character. They haven't been enacted in any authoritative institutional process. There's no separation of powers principle in the United States Constitution. There's no separation of powers principle enacted in the written materials that comprise the British Constitution. They emerge not just from case law, but they emerge from centuries of reflection in our political morality, and their consequent character as non-textual law, which given the absence, and there is the consequent character as non-textual law, which given the absence of any canonical formulation, generates a sort of looseness and flexibility that we've found with other principles in our analysis. This may be helpful to advocates who are deploying a legal argument supposedly resting on them, but for that very reason it makes them unhelpful to those whose institutional task it is to decisively resolve some adversarial issue. I don't just mean that these principles are loose in the sense of being verbally indeterminate. What does separation mean? What are powers? That sort of question. I mean, they are, But they're also loose in the more substantial sense of it's not being fully clear or agreed on all sides as to what we're trying to do with them. Basically, we set up these grand principles to denote, respect, and proclaim what we think is important in political theory. But there's a disagreement about which of these principles is most important in a particular setting, and about which versions of these principles we should be trying to give effect to. Sometimes this is evident from the use of competing formulations. Think of the array of variations on the theme of the rule of law that I mentioned in Lecture 2. You could call it the rule of law, you could call it the principle of legality, you could call it the principle of the rule of laws, not men, you could call it the principle that says no one is above the law, or that we have one law for everybody, or we talk about the rule of law as opposed to rule by law. There's dozens of different formulations that compete and jostle for our attention when we use this idea. Or if we're talking about separation of powers, there too we have a bunch of adjacent formulations, not really cognate in vocabulary or syntax or logic, but which nevertheless seem to be irretrievably entangled with one another in the use that is made of the phrase. So separation of powers, checks and balances, enumerated powers, co-equal powers, the dispersal of power, and so on. Again, 5 or 6 different formulations that point us towards different concerns and different interests in our constitutional structure. When separation of powers is in the offing, any of these formulae may be used on both sides, or even on one and the same side from page to page in the same argument, despite the considerable differences conveyed by each of them if it is understood literally. My point, as before, is that the application of these principles does not enjoy the benefit of authoritative enactment. Nobody laid down a separation of powers principle. So there's nobody whose diaries we can go to find out in an originalist spirit what the idea meant. But there is this slight difference. Although grand political principles may not have been enacted by any authority whose historical intentions might settle the terms of their application, some of them do come nevertheless trailing vague and drifting clouds of at least theoretical authority. For example, in America, everyone knows that if you want to talk about separation of powers, you need to resort to the arguments of James Madison in number 47 of the Federalist Papers. Madison spoke of, and I'm quoting, the political maxim that the legislative, executive, and judiciary departments ought to be separate and distinct. He said, and he was responding to anti-federalist complaints that he and his fellow federalists didn't take separation of powers seriously enough. He said, no political truth is of greater intrinsic value or is stamped with the authority of more enlightened patrons of liberty than that on which the objection of the anti-federalist is founded. The accumulation of all powers, legislative, executive, and judiciary in the same hands, whether of one or a few or many, whether hereditary, self-appointed, or elective, may justly be pronounced the very definition of tyranny. There you have, it's not exactly an enactment, but there you have something like an authoritative formulation. And he indicated that he himself was subject in turn to some theoretical authority in these matters. He said, the oracle who is always consulted and cited on this subject is the celebrated Montesquieu. If he be not the author of this invaluable precept in the science of politics, he has at least the merit of displaying and recommending it most effectually to the attention of mankind. And not only do we have this historical figure Montesquieu writing about 40 or 50 years before Madison, but Montesquieu also had an institutional exemplar. So Madison says, the British Constitution was to Montesquieu what Homer has been to the didactic writers on epic poetry, as the latter have considered the work of the immortal bard as the perfect model from which the principles and rules of the epic art were to be drawn, and by which all similar works were to be judged. So this great political critic, Montesquieu, appears to have viewed the Constitution of England as the standard, or to use his own expression, as the mirror of political liberty. I mean, a very, very odd situation, because suddenly Britain is being cited as the model for a good, well-functioning constitution in the midst of America's revolt against British institutions and British ideas. And actually, Madison and others made it clear that this was an equivocal paradigm. For in England, the powers of government were and always have been entangled in all sorts of ways. The effective executive being a committee of Parliament, the highest court being for a long time a committee of the House of Lords, and so on. So we have this equivocal archetype actually grist to the mill of somebody like Madison, who didn't want to invest too heavily in the separation of powers because he wanted an effective rather than a paralysed government, and he was actually quite defensive about his attitude towards it. And by the way, in case anybody's interested, my own personal view is that Madison's disquisition on Montesquieu and the British Constitution has a whiff of irony, maybe even sarcasm about it. Oh, the great oracle Montesquieu. Oh, the British Constitution, let us bow down and worship it. But that's neither here nor there. But isn't the separation of powers authoritative in a more direct way? In a constitutional way? Isn't it explicit in the distinction drawn in the American constitutional text between Article 1, which is about the powers of the legislature, and Article 2, which is about the powers of the executive, and Article 3, which is about the powers of the judiciary? Well, of course, that delineation is inconclusive. The constitutional text that Madison was defending simply sets out separate articles in the Constitution, but separate reference to three things doesn't necessarily connote a normatively insistent separation of them. Fact is that there's nothing said in the constitutional text about a normative separation, not even anything about the evaluative importance of separating the powers. We who invoke the separation of powers in legal argument have got to figure this out for ourselves from very unpromising material. For the constitutional text ordains in some cases that one power may play a role in the decision-making of another power. The Senate plays a role, along with the presidency, in the ratification of treaties or the making of judicial appointments. Separation of powers? No. Joinder of powers. Or that it ordains that one of the enumerated powers can operate as a check on the ability of another one, and that despite being co-equal in another one of the formulations that we are given, that branch is entitled to prevail in the other's realm when there is disagreement. Have you ever heard of the judicial review of legislation, for example, or a presidential veto? These all seem to be cases where the powers interfere with one another. And this is supposed to be a good thing. Not only is it supposed to be a good thing, it's supposed to be an instance of the separation of powers. Go figure what that's supposed to mean. Indeed, the separation of powers is sometimes turned inside out just to mean checks and balances, which, although diametrically opposed to any norm of separation, is nevertheless identified with it by many theorists and politicians. Checks and balances are based on the very interaction between powers that separation is supposed to preclude. In this theoretical back and forth, the alleged co-equality of the branches is violated, sometimes by judicial supremacy, sometimes by a functional argument for the primacy of the legislature in lawmaking, and sometimes, as right now under the Trump administration, with a sense of the necessary ascendancy of the executive. So we have that uncertainty as well. Not only that, but at least two of the three branches entangled within their own remit, important and separate governmental powers which might sensibly be distinguished. The legislative branch has the responsibility of budget, as well as the enactment of laws. The executive branch has responsibility for foreign policy and war, as well as for the enforcement of the laws at home. John Locke's warning that this entanglement of executive powers poses a threat to the rule of law is not really taken into consideration. And as I said, anyway, there's no canonical account of why separation of powers is important to the extent that it is. Political philosophers have offered various theories, but such theories may or may not have a bearing on the issues under consideration in court in particular cases. Madison proclaimed that the justification for separation of powers was stated by Montesquieu. But actually Montesquieu's justifications, what we know of them, were mostly tautologies. Montesquieu would say things, we don't want the powers to be concentrated in one institution, because if one institution constituted all these powers, the powers would not be separate. Yeah? And that would be a bad thing. So, Madison alluded to some other justifications in the spirit of the laws, but he wouldn't say what they were or where they were. So, listen, I'm not really urging the absence of constitutional authority for the separation of powers. It has emerged from our traditions on both sides of the Atlantic. But I am arguing that it can't really settle anything, since its interaction with checks and balances, or with Madison's doctrine of constitutional moderation, leaves its application quite indeterminate. When it is said that an action by one power may threaten the independence of another, how do we know that this relation is supposed to be governed by what we could formulate as a normative separation? Or how do we know that it's as opposed to representing an implicit setting up of some check or a particular balance or guardrail? We just don't know. And it doesn't help that the checks and balances idea and the separation idea are run together in the same formulation. It's not inappropriate to cite the separation of powers, if only for decoration, in any case where the extent and interaction of institutional authority is at issue. But invoking it as a deal clincher, that's what I'm worried about. For such a use would involve having to settle for a particular case on a particular formulation of separation of powers and a particular account of the weight that it might have as against other rival principles. I mean rival in regard to the case at hand. And that is made immeasurably more difficult by the fact that some of the considerations which militate against the separation of powers make their way into our jurisprudence as conceptions of it rather than explicit rivals. So the separation of powers is definitely a political principle, and no account of our constitutional tradition would be good without it. And just because it's a political principle doesn't mean to say it works as a legal principle. But of course the logic of the US Constitution, or any constitution, nowhere consists in its deference to just one principle. Multiple principles jostle with one another in the constitutional text, and in the case law we have built up around it. They crowd each other out, they cut each other down to size, as the framers of various generations strive to explain how the constitutional machinery they are putting together is supposed to work. A given legal position or the authority of one or more powers of government might represent a resultant of the application of two or more or a dozen such principles. For example, the principle of separation of powers has always jostled for space with the principle that recognizes the need for a strong and decisive central government, a policy which in turn, as we shall see, jostles also with the rule of law and the principle of limited government. So we really are in the same sort of situation as we've been in since lecture 1. There are too many principles, and their weight against one another is not necessarily something that is clear to us when we're working with them. Now, I'd like to illustrate this with the case that I mentioned, Trump against the United States, decided on July the 1st, 2024. Chief Justice Roberts wrote for a divided Supreme Court that a former president of the United States, so this in 2024 they were looking back to the first Trump presidency, was entitled to rely on a principle of immunity against criminal prosecution for actions performed during his presidency, if the actions in question fell arguably within the ambit of his official powers. It referred to prosecutions that had been commenced against the president for trying to persuade electoral officers to find 11,000 votes, which he thought was necessary for his re-election, or that he attempted to browbeat some of the electoral officials into miscounting some of the election results, or he tried to persuade the vice president to interfere with the process of certifying the votes in the Senate at the end of the electoral process. For all of these occasions, you could say two things about them. These were patently unlawful actions, but at the same time they appeared to be the president exercising powers, conferring with the vice president, supervising the counting of votes and so on, exercising powers that fell, at least in some respects, into the remit of his Article 2 authority. So it was a difficult case, particularly given the way in which the Chief Justice thought that the president's powers were very extensive, and so something falling within the ambit of his official powers would really cover a great many ideas. The case had to do with prosecutions, as I said, that had been launched against Donald Trump for his attempts to overturn the result of the 2020 presidential election. To be fair, Chief Justice Roberts' position was qualified. He wanted immunity only for actions with some arguable connection to the functions of the President's office. But still it was disturbing. The Chief Justice thought that presidential immunity had to be acknowledged as a principle implicit in the Constitution's respect for the exercise and exigencies of the executive power. This he regarded as part of the interbranch deference that separation of powers would require. Now, the Chief Justice knew that this was controversial, and he acknowledged that there was no text available to settle the issue. He said, "True, there's no presidential immunity clause in the Constitution, but there's no separation of powers clause either. Yet the doctrine is undoubtedly carved into the Constitution's text by its 3 articles separating the powers and vesting executive power solely in the President. It is these enduring principles," Chief Justice Roberts concluded, "that guide our decision in this case, even though none of them is represented by any univocal form of words in the Constitution." So that was Chief Justice Roberts' view for the majority. But these weren't the only principles cited in Trump against the United States. Chief Justice Roberts also cited what seemed to be a principle of presidential decisiveness. And the justices who found themselves dissenting from Chief Justice Roberts' opinion cited other principles, notably what Justice Sonia Sotomayor called the principle foundational to our Constitution and system of government that no man is above the law. We could call that the principle of legality, or the principle of the rule of law. Justice Ketanji Brown Jackson cited the principle of the rule of law, calling it a foundational presupposition of our constitutional system. People are the sovereign and the rule of law is our first and final security. That was not in the founding text either, but it too is etched in our constitutional consciousness, whatever that means. It wasn't that the dissenting justices repudiated respect for the executive. They just gave respect for the independence and effectiveness of the executive much less weight as against the other principles they cited. So there's another familiar problem for us. In addition to questions of provenance and questions of formulation, we have to ask how a norm's weight is determined in a case where principle is matched against principle, where more than one such grand principle is brought to bear. So, for example, we have to ask, how does presidential immunity, protecting the president from prosecution so that he can go about his business as president undistracted, how is presidential immunity, how does that stand in relation to the principle that no one is exempt from legal accountability by virtue of their exalted position in the hierarchy of authority? No one is above the law, the principle of legality. Obviously, any form of legal immunity is a rule of law problem, since it exempts some individual or class of individuals from legal obligations that apply to the rest of the community. But the case of presidential immunity might be thought of as particularly troubling inasmuch as it fixes a lack of legal accountability at the visible apex of the state to benefit the highest office holder, defying Thomas Fuller's famous adage from more than 300 years ago, "Be ye never so high, the law is above you," or as it was cited by in Private Eye, by the Private Eye's legal correspondent, who worked under the title of Justinian for the Money. He used to cite it as, "Be ye whomsoever ye may be, the law is an ass." But at any rate, be ye never so high, the law is above you. We might want to insist that an office holder like the president has a particular obligation to respect all the laws and to communicate respect for the whole legal enterprise, for all its processes and institutions and requirements. This is partly because we want the message of respect for law to be communicated vividly. We want what is sometimes called the highest power in the land, or by President Trump, the highest power in the world, to be associated visibly with legality. Justices Jackson and Sotomayor seem to see the rule of law as the uber principle in our political morality. And perhaps they are right about that, though it would still be a further question what the rule of law entails. So you see how the fluidity, the looseness of separation of powers makes it very difficult to to get any determinate results from it. Chief Justice Roberts' argument for presidential immunity turned crucially on his understanding of the importance of the decisional role of president, what I referred to as a principle of presidential decisiveness, something to be encouraged. What the Chief Justice said was this: the framers, that's the guys who wrote and ratified the Constitution, deemed an energetic executive essential to the protection of the community against foreign attacks, essential to the steady administration of the laws, essential to the protection of property, and essential to the security of liberty. The purpose of a vigorous and energetic executive, they thought, was to ensure good government, for a feeble executive implies a feeble execution of the government. The hesitation to execute the duties of his office fearlessly and fairly that might result when a president is making decisions under a pall of potential prosecution raises unique risks to the effective functioning of government. And Roberts associated this in turn with the separation of powers, or at least that is what he said his decision turned on. But the separation of powers is not the same as the importance of any particular power, or if it is, then separation of powers is being turned upside down rather than inside out, so that one can infer one power's importance over all the other powers merely from the fact that it rates a separate mention in the Constitution, despite the fact that the other powers have exactly the same credential. In my view, the Chief Justice's argument would have been more persuasive had he acknowledged that it involved a trade-off between the rule of law principle on the one hand in at least some of its formulations which plainly argue against presidential immunity, and the value of executive effectiveness, which the Chief Justice made so much of in that passage I quoted a moment ago. Proponents of the rule of law should be troubled by the idea of presidential immunity. Yet at the same time, maybe trade-offs are trade-offs, and they may grudgingly concede that since the rule of law is not the only important star in the firmament of political values, perhaps it has to yield sometimes to the separate, independent and competing value of executive effectiveness. The rule of law is important, but it's not the only good thing in the world, and those of us at least who use a thin conception of it, as jurists like Joseph Reyes have argued, and as I have argued, necessarily have to concede that sometimes it must yield to other principles, other ideas like social justice or human rights that aren't themselves connoted by the rule of law. If the rule of law sometimes loses in the balance with democracy or human rights, perhaps it also sometimes loses in the balance with executive effectiveness. Or perhaps not. At any rate, the Chief Justice was not even prepared to acknowledge what his dissenting colleagues insisted on, that the rule of law was crucially at stake in the matter, and that both of these principles needed to be addressed. You can probably tell that all along I really wanted to talk about the separation of powers rather than legal principles in general. And that's not quite true, but I sneakily organised the third lecture so I'd have an opportunity to say something about separation of powers. But I want finally to bring back into our discussion the distinction made yesterday between normative and non-normative principles. Maybe the looseness of the separation of powers, which generates only controversy when we try using it to resolve cases, is less of an obstacle to the principle's usefulness as a characterizing principle. In that domain, its endemic looseness, and in a way its subjective dependence on the scientific interests of the analyst, make it into a useful resource for positive political theory. The poorly defined quality of its formulation may actually enhance its usefulness for the role of characterizing principle, like the loose senses of nationhood and liberty conveyed in Fritz Scholz's 7th and 8th principles of Roman law. Let me emphasize, though, that it's not only legal normativity that's a problem. A characterizing principle may be politically and philosophically normative. Politicians often use characterizations of one political system to lay down strategies for building another. What Madison said about Montesquieu's view of the separation of powers in the British Constitution can be read that way if we discount the sarcasm. I think it's perfectly appropriate for constitution makers to invoke and rely on a principle of separation of powers. I think it's perfectly appropriate for constitution makers to invoke and rely on a principle like the separation of powers. But being an appropriate normative resource for constitution making is not the same as being an appropriate resource for constitutional interpretation. That distinction was made famous by Justice Scalia when he was discussing alternative visions in European politics of the principle of the allocation of powers between the federal government and the states, or between the European Union and member states of the EU. Scalia said, "The dissent would have us consider the benefits that the other countries and the European Union believe they have derived from federal systems that are different from ours. We think that such a comparative analysis is inappropriate to the task of interpreting our Constitution, though of course it was quite relevant to the task of writing them." So you can see it was a reasonable suggestion. Nothing that I've said here is intended to show that the normative use of legal principles is impossible. If she likes, a judge can just take up a discernible thread of coherence from existing legal materials, announce that it's a principle, cite it as the normative ground of her decision, and in Rousseau's words, find people simple enough to believe her. She can do it, it can be done, and that's more or less what Chief Justice Roberts did in Trump against the United States. And in case after case, article after article, judges and legal scholars do the same. They take for granted that there are such things as legal principles, grand or small, pitched at a pretty high level of abstraction, which they can infer from existing legal materials, that they can turn a blind eye to alternative readings, and that they can apply normatively to the resolution of present and future hard cases. The arguments that I've given throughout these lectures are just arguments not to discredit that, but just to hesitate when we use principles in that spirit. So, ladies and gentlemen, it's time to bring this series of lectures to an end. I've tried to explore the problem of reposing too much hope in the category of legal principles to fill in gaps in the law and to restore the appearance of dignity and rationality to the legal process. Inspired by Ronald Dworkin's early jurisprudence, some of us had envisaged that principles might take their place as legally normative provisions, authoritative in their own way, in the array of resources that judges and lawyers could draw on to settle hard cases, in a way that one's adversaries in the case would have to acknowledge. And not just settle them, but unsettle them too sometimes, in order for us to have the opportunity to decide a case in a different direction from that suggested by acknowledged legal materials like statutes or precedents, including other legal principles that were already in play. That was what was going on in Riggs against Palmer. Ronald Dworkin, former Quain professor here, my mentor and friend, Ronald Dworkin thought that the discernment of legal principles might provide a basis for his right answer thesis, that there was a way to argue in law and go on arguing even when the provisions of positive law didn't seem to point to a resolution. But the defining looseness of legal principles, an artifact of their lack of authoritative provenance and the absence of canonical formulation, meant that this proved too much. Both sides could go on arguing along these lines. The principles cited by the petitioner could be turned inside out by the respondent. Other principles could be brought in too, so both sides could claim the rationalist credentials that a principled jurisprudence seemed to offer. For both sides can dip into the reservoir of platitudes and sayings, of maxims and analogies to draw out something dignified sounding and serviceable for the particular forensic task they have in mind. One side or both might make something up in a high-minded spirit to get to a principled argument for their position. Herbert Hart, was right in his postscript in the concept of law to acknowledge that when rules prove indeterminate, the good lawyer or the good judge doesn't just push the law books away and start legislating. Very often, said Hart, they cite some general principle or some general aim or purpose, which some considerable relevant area of the existing law can be understood as exemplifying and advancing, and which points towards a determinate answer for the instant hard case. But available principles are abundant enough and loose enough to allow one's opponent to do the same. And that's why we should pay attention to Hart's saying immediately after the concession I just mentioned, that although the procedure certainly defers, it does not eliminate the moment for judicial lawmaking. Eventually the judge has to say, I'm going to follow this principled line of argument rather than that principled line of argument. And I don't want to say that that's purely arbitrary. I just want to say that that's the nature of where we're left in the decision of hard cases. For there is still the task of resolving the face-off between the principles cited by me to make the case for my client and the principles cited by my adversary, sometimes the very same principles read in a slightly different way, to make the case for his. Law is an adversarial business. And it doesn't become less adversarial just because one or both parties deploy the high-minded tones of principle. The fact that I can make up an argument which seems compelling to me is but a first step, and it was only this first step that Dworkin made with his introduction of principles into jurisprudence. When I make an argument along these lines, I have to consider all the ways in which the argument can be contested, with the same principles reconceptualized, perhaps turned inside out, as we've seen with the separation of powers being converted into the principle of checks and balances, or with other principles being introduced by my counterparty's attorney. That's been the negative part of my argument. It's not meant to be destructive. It's not meant to show that we shouldn't cite principles as rhetorical resources. But no party should act as though they had a monopoly on principled jurisprudence. More affirmatively, I hope I've been able to show that principles do have something to offer jurisprudence in the form of non-normative characterizing principles of the sort that we talked about yesterday, and the grand political principles that we've talked about in the bulk of this evening's lecture. In these endeavours, which matter both to legal science and to political philosophy, looseness is a virtue, contestation is something that enriches an argument, and originality is a resource that we engage as we engage creatively with what other people have made of our legal heritage. That's the virtue, that's the payoff of principled reasoning, not some spurious, majestic elixir to resolve hard cases in the law. That's it. Thank you very much.